Hi everybody, we're doing a short video lecture on the exclusionary rule, and we'll be putting up more on this as far as some other sources. One thing to understand about the exclusionary rule is the basic notion of it is that the police basically break the law themselves in order to solve a crime. So in other words, they commit a crime in order to solve a crime. For example, some examples include, let's say they beat a confession out of somebody. Well, that's at least a battery. It could be a felony battery with serious bodily injury. Let's say that they go in someone's home without a search warrant. That is trespassing, at least residential entry in states that have felony residential entry. So they're committing a felony in order to solve a felony. So what their basic theory of it is there's no way to act, that the government should be above the fray and not be like Dirty Harry, you know, where they're sticking a gun barrel in somebody's mouth or something like that. So this goes back quite a few years, around beginning of the Prohibition era, 1920s. There was also gun running. There's a number of other things. And there's a case called U.S. versus Weeks that said federal agents cannot use these type of tactics, which is violate the law, in order to solve a crime. And so in the theory of exclusionary rule was first advanced in the case of U.S. versus Weeks. So what we want you to do is, for one thing, brief U.S. versus Weeks, and then also look at another case called Wong Sun versus U.S., and you want to brief that and talk to us a little bit about what you come up with on those. And of course, it's always good to shepherdize anything like this that you do. So look at these different cases and shepherdize. And in the course of that, what you'll basically see is, first, that federal agents cannot use tactics like felony law violations in order to solve other felonies. And if they do, then the evidence is excluded or thrown out. Now, the further advancing of this was in the case of Wong Sun versus U.S., where Wong Sun actually went so far in that case to say that, the court said that even where one piece of evidence leads to another piece of evidence, all the evidence goes out. So even though, let's say, some illegally found evidence leads to probable cause to get a warrant to seek other evidence, then just because the whole process was based upon illegal behavior, it all goes out. You can't use any of the evidence. So that's the theory from the 20s and 30s and back further in time. Well, in the 1959-60 era, we know the case of Mapp versus Ohio. And so U.S. versus Weeks was basically applied through the 14th Amendment to the states, basically in the case of Mapp versus Ohio. And another case that stands out during that time is Miranda versus Arizona. And so the difference between Mapp and Miranda is that in Mapp it is an illegal search of a house without a warrant, so basically what we see is that this rule that's been around for quite a long time in the federal courts was finally being applied in the 60s to state court cases, not only for searches but also for seizure of the person of Miranda and more or less a forced confession. We've talked about that some before, where we've had cases where we're looking at an issue between the different desires and needs of the government versus the freedom and rights of the people. And so generally speaking, I get some people in here that are always willing to say, well, I have nothing to hide. Well, that's a wrong answer. I won't accept that. Because you're a U.S. citizen, got nothing to hide in like Germany or somewhere. That's what led you right into a Nazi existence in a Nazi country. And so basically by strictly enforcing the rules, even for the worst citizens, it made life better for the best citizens. So basically what we're saying is these tactics are not supposed to be allowed in the United States. And so that was the general rule up through the 70s. Well, what ended up happening, there's been a softening of the stance on this issue. And what they're saying is they've created now, the new thing is what they call the Doctrine of Inevitability. So basically, you know, we've got a situation is that we've made this strict hard rule that any evidence is found by using a felony. Well, now they're softening on it. They're using not only the doctrine of inevitability, but they're also using the good faith doctrine, meaning the policeman thought he was doing the right thing. He thought he was at the right house. He thought, you know, that he was doing the thing that he was ordered to do by the courts. And so it was not his fault that he got in the wrong house. And so he happened to find something, but it wasn't even at the right house. So, you know, consider one of these different things that I'm talking about here and give us your thoughts and comments on it. And we'll pick them up and work them through, let everybody have an opportunity to take a shot at it. And then, you know, we'll just see what comes out on the other end. So basically, give it a look. Let us know what you think. And hope you enjoyed this. I'll be back with some more things later. And like I say, we'll see you next time with a brand new show. Thanks a lot.